Well, good morning, everyone. We're just so pleased to be with you this morning. And what I think you'll find to be a very timely, kind of interesting topic. I just want to maybe, if I can, just ask, just for a show of hands, how many of you folks have some sort of mental health court at this point? So maybe about a third to half. And how many of you are thinking about moving in that direction, trying to develop that kind of a project? Okay, good. And I'll mention, too, that a lot of the principles we'll talk about today, I think, could also be helpful to you in problem-solving courts generally. So hopefully this idea of using standards to help build and then sustain the projects will be of some help. But I want to do a little more introduction, if it's okay, because I think these folks are just terrific to work with. I've just been honored over the last couple of years on this project here to work with Nicole and Kent. So I wanted to, if I can, Nicole, just ask you, brag a little bit about yourself. Tell us maybe your involvement with the mental health courts and research, and then we'll go to Kent as well.
Sure. So I'm with the National Center for State Courts, and I've been working with doing evaluations across the country on different mental health courts. I also, and I'll talk about this a little bit during the talk, but developed mental health court performance measures, a national set of performance measures that are adopted as part of the standards. So it's really exciting to be able to talk about some of the work that we did here in Arizona.
Thanks, Nicole. And Kent, Tina's boss. So
Well, I was on the statewide Arizona Mental Health Court Standards Committee that took the standards that Nicole brought to us, Nicole and the National Center brought to us, and adapted them for Arizona. There are a couple of people in the room who also participated in that effort. And it was a pretty long effort. I'm not sure how long was it, maybe 18 months or something like that?
Sounds right.
And I think one of the reasons I was there is we have a handful of problem-solving courts in Pima County, which is southern Arizona, for those of you that don't know. And we've had a mental health court since 2004. So we've been in operation for quite a while, but we haven't done a whole lot of research ourselves around the results and those sorts of things. So I think that's the reason for my involvement. That's the only excuse I can think of for them calling on me.
Thanks, Kent. And I was just privileged to serve as the chair of the Supreme Court Committee, helped develop these standards. Before that, I just was fortunate to work with some drug courts and other kind of problem-solving courts, mental health courts back at the Superior Court in Maricopa County. So what we hope to do today, I want to really have the panelists do most of the presentation, but as an overview, I will share with you just a little bit about the purpose, goals of these kinds of standards, kind of quickly talk to you about the Arizona experience so far, because our project was actually driven by some legislation, and it was friendly legislation, fortunately. And then we're going to turn to Nicole. She'll actually walk us through what was a national standards development, also some of the underlying research, and that was tremendously helpful to our committee. We actually had the Center on Contract helping us with the project from the evaluation standpoint and then actual development of standards. And Kent's actually going to walk us through the standards, okay, in some detail. And I think probably what's most intriguing is a measurement system, a performance system in there that he's going to talk about as well. And then we hope to have a little bit of a interaction with you folks. We really would like to have you throw, I see a lot of head knowledge out here in the group, including some folks actually who had participated with the Arizona court project. So I'd like to have some discussion. We'll share with you then some implementation strategies and then some areas looking into the future where we think some additional research would be really helpful. Still a lot of open questions. Program goals for these sorts of courts just generally are fourfold, and essentially what we're talking about is trying to maximize the use of all of our resources. And the note here talks about not just the jails, but the hospital, the mental health providers, and whatnot. And the stat I'll share with you, I guess about 20% of folks in jails and prisons at this point would be diagnosed as seriously mentally ill. And some folks would say it's even higher. That would equate to about 350,000 people across the country. Compare that with only about 35,000 in hospital beds, and it's that whole deinstitutionalization we had heard about years ago that impacts the courts. Also, these kinds of project mental health courts would be designed to help reduce recidivism, help with public safety. Our standards in Arizona that we'll talk about actually also go to the work of the probation field officers with specialized caseloads. We're also trying to promote mental health stability, and so when Kent talks to you, he'll talk about very flexible kinds of plans. The idea that continually revisit the treatment conditions and be pretty agile about making modifications and responding very timely to any kind of new issues that would sort of arise with this very high-risk population. What's the the purpose. Well, why even develop these standards? How are these used? And I know in Arizona some folks said to us, are you going to try to accredit the courts? Do we need to be credentialed? We have programs and projects that are running, and our response was, no, not at all really. We are hoping the standards could be of help to you, just as we've used space standards in the past, caseload standards, things of that sort. And so the first would be to help folks designing a new program, to give you some sort of a framework for the design of the program, helping the courts with the funding needs, resource needs, whether you're using existing resources or perhaps going to the city, to the county for some additional staffing and whatnot. Trying to create accountability, and I know this is huge with the NACM core now, okay, the metrics for performance measurement, the idea of data-driven or evidence-based practices, and so the standards you'll see do have a pretty comprehensive measurement system. We're hoping the standards would also help with training, technical assistance, things of that sort, help improve confidence and whatnot. And then probably most importantly, and Kent will talk about this a lot, would be the stakeholder groups. You have the staffing at the courts, but we're suggesting you also need some governance. You probably need an intergovernmental agreement or a memo of understanding. And so the standards kind of talk about how to formalize this so the program does not fall apart every time you change leadership. Maybe you have a new presiding judge or a new administrator. The program is sustainable over the years. And then last, we were concerned if we don't develop these kinds of standards, somebody else might. Okay, it might actually come from the governor's office, another group, and maybe well-intended, but we thought this is the kind of thing, it is central to court administration, it really ought to be governed within the court family. Arizona, just real quickly, and I wanted to let you know that this has always been a part of their strategic direction, and you'll see some notes here about collaboration with other justice partners, evidence-based practices, not only in the courts but in our probation services. And this last bullet point I think is interesting. We've had some legislation, fortunately, that allows us now to share jurisdiction for both our veterans courts and also for the mental health courts. And so the idea is that you may not have enough resources or staffing to handle this on a small to mid-sized court, but maybe pool with some of the neighboring courts, and then the judges there could share jurisdiction. And this has been really well received, especially by the Veterans Administration with veterans courts. Easier for them to send out a provider to one location. So that's been a pivotal part of these kinds of programs. The legislation I mentioned, it was friendly, but it made us a little nervous, honestly, and it had 3 or 4 provisions. First, they did ask us to formally evaluate the mental health courts in Arizona, each of those, and so that's where we brought the National Center in, Nicole and her team. They asked us to set out standards for the courts, performance and also program operational sorts of standards, develop some kind of curriculum for training for judges and for the staff, develop procedures that would be used for the placement of these cases, the criteria for movement of cases and so on, and then also to consider any other kind of future directions and make recommendations. And so, in fact, the project you'll hear about actually developed a plan, the standards, and then actually submitted materials to the legislature and to the governor. Here's the administrative order that created that committee, and it was kind of a broad charge asking us to work on the evaluation component, but then to actually develop the formal standards. And it was sort of a multidisciplinary approach. We had, I know you folks have had these kinds of projects, but judges, administrators, clerks, but I thought was interesting here also some of the mental health providers, actually had some psychologists and others on the panel, prosecutors, defenders, and we tried to have a good cross-section of small courts, large courts, and whatnot. And I think it was also important here, they decided, the Supreme Court, that these standards should apply to both our limited jurisdiction courts and Superior Court. And that was a little tough because those courts operate differently. Generally for limited jurisdiction courts, they're pre-trial, disposition, if you will. And that's one of the incentives for folks to finish the programs. Superior Court generally would be post-dissolution or post-disposition, post-conviction. So a little different kind of a model. But the court said, let's try to have standards that would apply to both of these groups. And so the courts in Arizona, we looked at 11 courts there, and I won't read these to you, but I think it's interesting. Tucson actually was our first pioneer court, a city court there, starting back in 2000 in Kents County, and then you can see that it expanded, and it's sort of an interesting cross-section as I look at it. Some of these are fairly large operations, others are maybe just 1 or 2 times a month that they would provide these services. So with that background, I'm going to ask Nicole to kind of walk you through the work they did. They were brought in to help with 2 areas, the evaluation of the program, and then secondly, the development of these national standards. So Nicole, please.
Thank you. Yeah, and so as Marcus just mentioned, there were these 11 different courts that were listed up there. We actually started out looking at 13 different programs. There were 2 in Phoenix, though, that ended up not really fitting the definition of what a mental health court was. They didn't have the continual oversight of judicial review hearings. And then there was another program that was really looking at competency screening, pre-competency before they would send it up to the Superior Court. And so it was a valuable program, part of their consolidated mental health program, but it wasn't necessarily a mental health court in the traditional sense. So we ended up describing those extra 2 programs, even though we only did an evaluation of the 11 that were mental health courts that the standards would apply to. So I wanted to give that a little background there, and then also mention that since the time of our evaluation, which was in the fall of 2013 and the spring of 2014, a couple new mental health courts have come up in Arizona, and so these standards would certainly be applying to them. And that was one of the purposes of these standards, was to try to provide guidance to those who are newly developing their programs. So with that, some of the findings from our evaluation, really it was very interesting to see the diversity, which was really embraced. As Marcus mentioned, also there's these pre-adjudication models. There's also the post-conviction, probation really based models of specialized probation caseloads. And so really trying to figure out what's going on with each of these courts, and are they effectively operating as they intend? So what are their goals? So we went through and we asked people what their individual goals were, and how they thought that everything was operating. So we interviewed folks in all of the courts. We did some phone interviews as well as some in-person site visits. And some of our findings was, let me just highlight a couple things here. The teams were really dedicated. And what I mean by that is that, we had public defenders, there were court-appointed attorneys, there were people who had this not as their main responsibility and job, but they did this on the side. And so they were really dedicated to this and really valued the program and wanted to see it succeed. And so, the dedication was really notable. They were also very innovative. And as expected, when you're dealing with interagency groups, you're going to have to collaborate, and you have structural restrictions in some ways. Sometimes it'll offer you some opportunities. But because of that, a lot of the court programs were very innovative at trying to figure out solutions that would better serve the participants, despite any of the structural barriers that are up there. And they were very collaborative, trying to bring to the team different expertise, especially from treatment, but also including housing specialists and others, to bring together that team-based approach, which is really important in the decision-making that they do. Then also, especially in the rural areas with the mental health courts, there was really a wide array of services that were able to be offered. And in particular, I'm just highlighting the housing specialists and peer mentor specialists. And at the time of our visit, there was really a trend that I saw where they were newly inviting these people to join their teams as core team members. So there was a housing specialist that would join the team, or there was a peer mentor that came to all of the staffings and attended the dockets. And so that was really valuable to see that they're trying to incorporate more services to attend to these participants in a more holistic way. And certainly there's the value-added linkages with treatment services. A lot of these folks had been involved with, they call the Regional Behavioral Health Authority in Arizona, which is the state mental health department. So a lot of these people had already had some exposure or had their names in that system. And so trying to reconnect these people, but then also taking those who had never been connected and try to make that connection for them was really a worthwhile effort and part of our findings. So based on those findings, there are also some challenges that were faced, and this is something that I would say is not unique to Arizona, but is really a national issue. Limitations. One of the limitations was that the program performance data that was available to address the stated goals of that particular program were really missing. And like I said, this is a problem across the country in terms of being able to say, if your program is developed to efficiently link people to treatment, if your program is developed to reduce recidivism and to increase stability in participants, what data do you have to show that your program is operating in that capacity and is effective? And what we found is that they had very limited data to be able to monitor that and manage with the data to see if they could make any changes to the programs to help better improve their performance. There was also limited data on the target population. What we found is that there is information about that, but oftentimes it was stored with the different stakeholder agencies. So a treatment provider might have a lot of information about the diagnosis, the clinical history, but whether or not that information was warehoused with the court and able to run reports on this and pull out that information for performance management was where the limitations were. And so that was one of the challenges that we had noted. And then oftentimes self-identified lack of training across the team members, just saying that they would really like to have more information about mental illness generally, as well as some of the other issues. So a lot of the team members felt like they really didn't get some core training that they felt would be valuable to them. And then another challenge, which again is a national issue, not necessarily just with Arizona, but that the programs are operating without full support of all the representative agencies. So all the different stakeholders. Usually what I see when I go across the country is that there's one agency that's not in full support of the program. And what ends up happening is that there is distrust, and sometimes there's a lack of information to be able to make decisions because of that missing representation of that person. And so what do you do about some of that? Well, some of our recommendations are based on the findings. And so the recommendations we gave, I'm just going to go through a few of these. One was that we recommended that they formalize commitment from these stakeholder agencies. And I think this is important partially because of sustainability issues. If there's an individual who's on the team as part of the core team, if that individual goes on to another position, what happens to that role? Is that role going to be continued in the same manner for sustainability purposes? And if you have formal commitment from the agencies and the leadership at those agencies, and put this into, for instance, a memorandum of understanding, you get written commitment. But in addition to that, you also get clarification of the roles, that they're written, and there's a lot more understanding by the different team members, and it helps to just make this work a lot better. Some of the people that we talked to in the interviews would say, well, I don't know what that person's role is on the team. If you don't understand what that person's role is, that's a problem. So having these written, oftentimes in policies or procedures, can really help establish the team, create more trust and collaboration among the team, but also to help with sustainability issues. We also recommended to seek training for the mental health court members, partially per their suggestion, but this would include judges. And some of the issues that were raised as far as the topics that would be most valuable were just generally about mental health, mental illness, diagnoses, psychopharmacology, and then some of the new trends that are out there in treatment. For instance, the release of the DSM-5 that changed the way that we identify Access 1 versus Access 2. Some of the courts were only accepting Access 1 diagnoses, and if that's the case, then without the distinction there, you need to understand better what those changes are and how would that impact the clinical eligibility criteria. Also, trauma-informed care, very, very big trend. Better understanding how do you respond to people who have been through trauma? How do you best respond to people who have different types of mental illness? And so some of that was needed and even requested by the mental health court team.
Nicole, you might, not everybody in this room is going to know what the DSM-5 was.
Sure, Diagnostic Statistical Manual, thank you. And that is where it identifies the different clinical diagnoses for serious and persistent mental illness, and Access 1 differentiates Access 2, which is a personality disorders. So it helps to identify the diagnoses, the mental illness diagnoses, that could be used to determine whether somebody would be appropriate to be eligible for a mental health court versus not. Some of this could be based on whether the treatment is in existence or whether these people are best served in that capacity of this type of a program. So the DSM is the main manual that the clinicians use. And the 4th version versus the 5th version is an updated version that helps to explain some of the diagnoses, the criteria for making those diagnoses for the clinicians. Thanks, Ken. Few other recommendations. We've got whether or not the courts can really assess whether or not they're serving their target population. So once it's been articulated who you're trying to serve, then can you accomplish those goals and identify that these are the people you are indeed serving? So again, it goes back to the sustainability through some data elements and data tracking. And prioritizing the continuity and sustainability through these standards through data infrastructure. So right now, there's a trend across the country of looking at implementing these case management systems that allow different agencies outside of the court to input information that can be used to make the decisions. So oftentimes people are emailing, faxing, calling, reporting information to the team to be able to make a decision when the person comes before the judge on a status review hearing. That information is really valuable. But what we saw in the courts when we would observe them is that each individual agency, so for instance, the different treatment providers or the public defender's office, they each have their own system that they need to access while they're in their staffing or while they're in the docket. Sometimes there's questions that come up, and they need to access their own information to be able to answer that. So that means each individual agency is recording separately the same information. And you hope that it's all consistent, right? So there's some data quality concerns too if that situation arises. But if you do this web-based sharing case management system, which there has been developed especially for drug courts, you have to have the data sharing protocols established as well. So identifying who can view what information, what's protected information, what is important for another team member to see versus should be restricted. So it could be, you know, a one-way, they provide information to the court, but some of that information and the data sharing protocol should be established. So I think that you know, having some sort of data infrastructure in place to help them to gather, warehouse the data, as well as to manage with the data and do the reports is really valuable. And then a final recommendation is to really consider what's going on with the number of people who are served and the types of people who are served. What we heard was that a lot of these courts were operating at capacity or sometimes even above capacity. And if that's the case, it might make sense to think about resource constraints and who's best served by this type of program. And what we can learn from the drug court world is that not everybody is amenable and best served with this type of a model. So in the mental health court, I think the same thing applies as who needs you know, a regular judicial supervision. Are these people of high criminogenic risk, in other words, risk of reoffending again? Are there available treatment options for people who have co-occurring disorders, substance abuse and mental health at the same time, they're co-occurring? If that treatment is not available, or if the level of supervision is not appropriate, we might want to think about what is our population that we should be serving, and thinking a little bit about the low mental health or mental illness needs, high, low, that little diagram there with the quadrants. Oftentimes those people who have the highest needs for mental illness as well as the highest needs for substance abuse are best served under this model. Sure.
Do you use something to determine high mental illness, or is it just sort of the clinical eligibility criteria? Like if somebody met all of your clinical eligibility criteria for your S program, would you consider them high mental illness, or is there some sort of tool?
There are lots of tools and there's lots of ways to define that. So I will be glad to explain that a little bit more later, but basically it just means that you have higher treatment needs and you have had past treatment failures perhaps, or you have a need to have more intense treatment. Perhaps you need to have medicated assisted treatment. There's trauma that can determine that. So there's lots of different tools that can be used to evaluate and assess different treatment needs. And a lot of those are also related to the criminogenic risks and needs, so the responsivity. So there's a whole host of things, and there's a whole host of different tools that can be used to put you into these different quadrants. Yeah.
Follow-up question on the tools. Do you find that it's helpful, or do you recommend that you use one assessment that everyone has access to? Or, I mean, I know that's really hard depending on the agency. They each have their own assessments they use, but what does the drug court that you nurses are, do they have a specific assessment that everyone that enters drug court has to have, or do you actually use the assessment that is available from the treatment providers and work with the clients?
Yeah, so the question is whether or not there's a particular tool that should be used to triage people and assess as to what they're coming in with. And I think that the drug court world is much better at this because they're dealing with people who have substance abuse or substance dependency, and it's a much clearer way to assess or screen for it, which then can be brought over to a clinician to make a diagnosis. The problem with the mental health and mental illness clinician world is that you're dealing with so many different diagnoses and individual differences across the participants that I think that you want to know whether or not they are screening for mental illness, and that could be something that would be part of an overall triage for somebody who's going into a problem-solving court of any kind, whether you're talking about trauma screening for individuals, or if you're talking about whether they have a substance use or dependence issue. But I don't know that I would go into too much in the intake process. I think that that's something that the clinician will do in terms of the diagnosis. So I don't think that there's a particular tool. There are some screeners and assessors tools that are out there that can be helpful in triaging which program they should be in. Does that help? Okay. So some lessons learned about the process of developing the standards. So we took the evaluation, we did some observations and interviews, and then we, as Marcus mentioned, developed some proposed standards for a working group to consider. And the working group was extremely valuable in helping to work through, from the individual court's perspectives, what was manageable, what made sense, thinking about some of the language. What I heard on the ground with the interviews was that there was a real concern about this effort and whether or not this was going to standardize all of the mental health courts. And how could that be possible when you're talking about limited jurisdiction, diversion courts versus a probation-based post-adjudication model in a superior court when we're talking about felonies. So the variation across the different models was immense, and to think about how could we possibly standardize all of them was a real concern. And in fact, I think it might even be elevated to fear, right?
I would agree.
So the standards, even using that term, I think resonated with some people about what does this mean? So we had to be very careful to talk through the language that we were using to describe these governing efforts, and really thinking about the current operations and holding so true to these current operations that they are very valued. Some of these courts had been operating for 10 years and had been doing things a certain way, and we're really holding true to the way that they were currently operating. So we had to have a discussion about what is a standard. And is a standard something that is a minimum? This is the bare minimum for what we want other mental health courts and ours to look like. Or do we want to be aspirational and try to reach up to these evidence-based practices of ideally, if we had all the resources in the world, how could we ideally operate this mental health court? And really, it falls somewhere in between there, right? Because you have to recognize the practical limitations. We don't have all the resources in the world. We can't change things completely because we have to work with other agencies. There's other structures that we're going to butt up against. And so trying to think about how can we do this and use the appropriate language to accommodate these variations. So as I keep talking about these variations in the models, you have to use specific language that can help to convey that this is going to apply in this way to these and perhaps in a different way to these types of programs. And accommodating different perspectives, different community limitations, rural versus urban, making sure that this can apply to a statewide system, which is really quite tricky. And then I would say that we also had some pretty, how should I say it, vocal opposition in the very beginning in the working group, and very valuable information from some of the individuals. But we're really against standards, not sure that they wanted the standards, not sure if this meant we were going to close the court down, and we're very vocal about it. And so trying to listen to those individuals, to hear what are their concerns, and to make sure that they understand that if they participate in the development, not only will it help to provide buy-in later on, but it also helps, as Marcus mentioned before, that they get to decide how these are developed as opposed to some other agency coming in and telling us what we're going to do. So really having the voice of those on the ground was really valuable. Difficult at times, but valuable. So research, the national research that's out there. We had to consult some of that and leverage that to try to even develop the working draft that we started with. the national research that's out there is admittedly fairly limited. We did consult, this image here is the improving responses to people with mental illness. It's the essential elements of a mental health court, published by the Council of State Governments Justice Center in 2007. And they lay out 10 different essential elements that need to be consulted for developing the standards. We also looked at some of the drug court work that's out there, partially because they're much more advanced than we are in terms of knowing what works and what particular program components work for which individuals. They've been studied a lot more, and they have a lot more consistency in the participants to be able to make meta-analyses that can say across all of these different research projects, we can confidently believe in these findings. So we looked at the Judicial Bench Book for drug courts. We also looked at the National Drug Court Standards, which we only had access to Volume 1, which in 2 weeks at the National Association of Drug Court Professionals meeting in 2 weeks, they're going to release Volume 2. But that helps to identify things like who should be on the team, what is the program structure, what type of assessment should we do for understanding criminogenic risk of reoffending, how quickly should we bring somebody into treatment and admit them into the program and the referral process, what types of treatment are most effective, how should we respond to these individuals. We want to make sure that they're stabilized with housing needs first before we start to address some of their criminogenic risks and deal with some of their cognitive behavioral therapies. And then what kind of court responses are most appropriate? Sanctions and incentives, and that's a hot topic, is whether or not you should put people in jail as a sanction and for how long. Confidentiality of the records, who's going to have access to it? And what does HIPAA say? And what do the federal rules say about the confidentiality of records? And then we also looked at some sustainability, which I'm referring to sustainability in the terms of performance measures. So how can we sustain this, develop performance measures that can help us to manage with data? And so I do have on the front of the desk here a brochure that explains the different mental health court performance measures that we developed in 2010. So if you want to take a look at it, it summarizes the 14 measures. So in 2010, we released this publication that has a user's guide as well as a template for being able to enter information and check your performance on different elements, such as efficiency. So how long does it take to get into the program? How long does it take to have the referral considered? And we pilot tested this with 4 different courts, mental health courts across the country. We tried to get a little balance between the rural courts and the urban courts, and we wanted to see whether or not they were practical, were they useful. So we went through a couple-year project to try to test those and see what they thought of them. And we made some adjustments based on that pilot testing. And then after the implementation, we had Georgia, Nevada, and Pennsylvania have implemented these statewide since then. There are some adjustments that are made sometimes at the state level. In Arizona, as you'll hear about, there's only some of the performance measures were chosen and selected for adoption through the standards. And so there's a set of 14 of them. Majority of these states are taking the majority of the measures. And then I also wanted to just mention that Yuma County, prior to the implementation of the standards, was already using some of the performance measures that were available nationwide. And since then, I believe that almost all of the mental health courts have started tracking this information. So it's really exciting to see how that's going.
Nicole, that's correct. And I might just,
Sure.
I know I see Debbie Schaefer here, so her court was one that stepped up. It's a city court in Tempe, and she shared a memo with the whole state saying, yeah, there's some work here, but we were able to make our way through the basic performance measures. And so that was a big help, because others then I think said, well, we'll step up. And so actually this will be, as it stands now, would be an annual requirement, but we're going slow, and we don't even have any plans for publication, but just trying to work with the courts on the collection of that kind of data. So Debbie, thank you.
It was the tool that the National Center provided that made it so easy, so thank you.
Yeah, and I've been working a little bit with Yuma on it too, and they've had some needs to alter some of what was developed at the national level. So when these are adopted for local or a state level, there certainly are tweaks that can be made to the measures that make sense for that community and what the structure is of that particular court. But they are intended to be a starting point and intended to be a place for, that should be applicable to most of the mental health courts across the nation. I just have a few other comments about the language that's used for these governing documents. The purpose of putting together mental health court standards, the purpose is really a huge continuum. And I have some of this work online that helps to describe what's going on across the country. In the fall, this past fall, we just did an effort to try to figure out what's going on for mental health courts and drug courts and the standards governing documents that they might have. And what I see is that there's this goal-setting guidance where state-level efforts are really just saying, here's some goals that we'd like you to attain, some key principles, or some recommendations for how you should operate your mental health courts. And then on the other side of the continuum, we have enforceable rules. And there's courts that are falling along this continuum, and it's partially describing how they deal with non-compliance, or do they deal with non-compliance. So there's certification processes that are going on in some of the states. Certification meaning that if you're not in compliance with what we have laid out, you will not perhaps receive funding. And yet, on the other side of the spectrum, the goal-setting guidelines, it's really just to say, here's a way to help you get started, or here's something that you should keep regularly checking and to see whether or not you can make some improvements. But there's really no repercussions if you're not in alignment or if you're not in compliance with some of these things. So I would say that Arizona falls probably right in the middle there with standards. It's really intended to try to assist the courts, trying to help them to identify these minimum standards that are that you'd like to have all of the courts operating at. But it also has some language in it that gives some aspirational of here's where we would really like you to be if you were in your ideal world. But the non-compliance piece isn't as far as saying without certification you're gonna be cut down, shut off, no funding, shut your doors. And so it kind of is a nice balance, I think, in the middle of that spectrum. And then here's just a view of the national perspective. There's 14 different states up there that have some governing effort going on that applies to mental health courts. The dark blue states are the ones that are specific to mental health courts. The lighter blue might have efforts that provide guidance or some sort of standards to problem-solving courts as a whole, but not specifically in mental health courts. And so there's Arizona, California, Idaho, Utah, Georgia, and New York that are specific to mental health courts. And really what we see here is that Arizona is one of the leaders in developing these specific mental health court standards and trying to tackle this issue of trying to go forward and give some guidance to the courts, but also trying to get up to that aspirational level. And so with that, I will turn this over to Kent to talk a little bit more about the administrative order and the standards themselves. Thanks.
Thanks, Nicole. Thanks much.
Thank you, Nicole. As Nicole alluded, boy, this is maybe a bit high, huh? The standards in Arizona were put into effect with an administrative order. You see a representation of it here. Essentially, while it adopted the standards, it did not require any specific court to create a mental health court. As we all know from the local level, it's best for us to decide when such programs or what such courts are best for our jurisdiction. But what it does do is tell us that if we implement one, we need to comply with these data reporting requirements and the standards that are specified. So we've all begun working on that. It was good, Nicole, for me to hear from you that local jurisdictions can tweak the performance measurements, because I hadn't heard that before. And I want Marcus to take note of that at the state level.
Take any notes about
so that all of us may not be reporting identically. That would be interesting. I didn't know how many of you are familiar with the Arizona court structure, and since we've talked about the differences between a pre-adjudication program and a post-adjudication program, I thought I'd just mention that Arizona is typical of certainly somewhat unreformed state structures. We still have 2 limited jurisdiction courts. We have a Justice of the Peace Court, which is essentially county-based, and then we also have municipal courts. So we have the 2 limited jurisdiction courts, and we had folks from both justice courts and especially from city courts who were part of this committee and part of the development effort. You saw those in Marcus's list of the courts that already have mental health courts up or drug courts up. And of course, then the general jurisdiction court, as you may have heard Marcus references, is called the Superior Court. Nicole was being very generous and very polite. When she talked about there were some folks that might have been voicing fears about this. Certainly we had one voice out of our county in particular who was quite concerned about these standards. We've been engaged in this for 10 years when this standards effort began to take place. And standards was, in fact, a scary word to our clinical coordinator and, in fact, to our mental health court judge. We have one judge currently engaged in mental health court. But then shortly thereafter, Nicole used the phrase, we just want to check your efficiency. So how many of you have judges that respond well when you tell them you want to check their efficiency? No, so you can understand why sometimes at the local level people get a little, twitchy about things like that. Let's see if this is what works. It does. See if there were some other. You've already mentioned a couple of things, so I won't go back over them. So this is the set of adopted standards as we've characterized them in the Arizona standards. I'm going to talk about each one of these, so I won't read them to you here. But some of these have been touched on, of course, by some of the information that Nicole has shared, as well as Marcus. So we'll just move right into Standard 1. And let me ask you, and you've already taken a couple of questions, but please don't hesitate to ask other questions as we go along. If there's something that's not clear or something that needs to be restated or explored in more detail, I'm happy to try and do that, and I'll rely on Deb Schaefer in the audience to help me with it. So the first standard pertains generally to the team that is guiding the mental health court, if you will, and particularly the participants in the mental health court, both the defendant participants and the participants in the team. The team generally should include a judicial officer, a member of the court staff who essentially represents the administrative structure for the court, and of course the judge is the mental health court judge. It would also include representatives from prosecution and defense. It should contain one or more of the providers, the mental health or substance abuse providers from your group. In Arizona's case, Nicole mentioned what we affectionately call the REBA in Arizona, the Regional Behavioral Health Administrator. It's actually not a state agency. It works at the behest of a state agency, the State Mental Health Agency, and under contract to that agency. There is some controversy. I don't know whether other states have similar entities, but it is essentially the umbrella agency for all the providers. So we have this umbrella agency representative present in our mental health courts. It's fair to say that in limited jurisdiction courts where they have fewer resources and availability of those resources is harder to obtain, they have found the participation of this umbrella agency's representative very helpful because they can gather these resources. In the larger jurisdictions, I think it was true in Maricopa, it was certainly true in Pima, the umbrella agency's representative was not always as constructive a force as just having the providers themselves in the room with us. We also believe in Arizona that you may want to include, and in fact in the general jurisdiction courts we believe should include somebody from probation, because it's going to be probation, just as in most of our problem-solving courts that are dealing, the probation representatives that are dealing with these people on a regular basis. And it's also quite advisable, I think this comes directly out of the drug court research, to have a peer mentor available. Any of you who have been engaged in problem-solving counts know that in veterans courts, for example, the peer mentor is absolutely essential. We've begun to find out from the research in veterans court, and we suspect it's no different in mental health courts, so we recommend that. And then, of course, there's the catch-all phrase, other folks who may be beneficial to the process or to the court for their expertise or their talent. So all of this team, it's a diverse team you can hear, at least in terms of their roles, has to work in this collaborative manner. And they all have the specific roles that you can imagine from them, from their titles. So they have to sort of subsume their roles to the good of the whole and the whole team. And after all, what's good for the participants. Now, as Nicole mentioned earlier, the recommendation in the standards is that these responsibilities be delineated in a memorandum of understanding or some sort of intergovernmental agreement. That, believe it or not, was also somewhat controversial for us because most of us did not have memorandum of understanding governing our relationships within this team. And in fact, in Pima County, we still don't have one. But I made a note to myself, you may have seen me making notes, but one of the notes I'm going to make when I went home, we have changed mental health court judges as of July 1st. And so one of the things I'm going to explore when we go back is whether now is the time to put an MOU in effect. So you can create these things without those sorts of formal written agreements, but that's not necessarily the best structure for the reason that Marcus cited earlier. When you have transitions, you lose that history and you may lose the relationships. And of course, Nicole and Marcus both have mentioned the importance of education and training, so I won't delve into that. Any questions about the team members or their roles and responsibilities? Yes, ma'am. Let me let you pause and let's get a microphone to you because I want to make sure the question's recorded.
Yeah, and as we do that, I'll just mention that there's a sample of that kind of MOU in the documents that you'll see attached with the committee report. So that might be a place to start if you want to look at that. Please.
When you were discussing the members of the team, you mentioned treatment providers. And how do you balance making sure that you have good clinical input with making sure that they're not advocating this for their agency? I mean, I don't know if having a REBA helps you guys get away from that, but that's one of the concerns I have when we're developing. You want to invite as many community providers as you can, but you want to be careful too that they're not advocating for a specific plan that would benefit their specific agency.
We have not had that experience in Pima County. In fact, what we found when we had the REBA agency involved was that the REBA agency was looking, from our perspective, more after its own, the REBA, the umbrella agencies' care and feeding, than it was after what was the best treatment for our folks. Our mental health coordinator has clinical experience, and so she was pretty competent to understand what the treatment providers were proposing. And we did not find that the treatment providers in Southern Arizona anyway were overselling themselves in terms of services, but I see Nicole has reached for the microphone.
Yeah, I'll just add to that, but that's a great point. And what I've seen nationally is that if you have somebody who has clinical training who operates on the team, oftentimes as the coordinator, but it doesn't have to be the coordinator, but some sort of clinical person can help to reduce some of the advocacy issues that you're dealing with. And we've also seen across Arizona especially, there was a difference between those who were case managers versus the actual clinician who was running the group, or and which model is better. And I'm not sure that the model, I don't think that's been definitively identified as to which is the best model. It's really critical to make sure you have the right information being transferred to the person who's on the team, though. So I would say if you're having that issue, you might want to look into having a clinical expert on the team as an advisor and or as a coordinator, because we've seen that as a really effective model.
Right. The REBA representative in Arizona has tried to put themselves in the case manager role, but they're not really in that role. They want to be they end up being a distributor of services. So I think your point's well taken, Nicole. Standard 2 addresses these issues with regard to how participants get into the program, what their eligibility is about, and the nature of the assessment. And of course, what you want to do is have predefined criteria for eligibility. You need to have, as we all hope we have for these programs, standardized criteria so that it's not a subjectively based entry decision, so to speak. And in general, those decisions should be made by the team. There are some distinctions between pre-adjudication and post-adjudication courts in terms of, I'll call it the authority of members of the team. In a pre-adjudication court, the prosecutor, after all, is the one that's going to let this person into what is essentially a diversion program. So the prosecutor probably has a greater level of authority, if you will, on that than perhaps in post-adjudication. But at the same time, the prosecutor also has to agree in a post-adjudication court program as to the, well, they don't have to necessarily agree, but the participation in the program is often part of some sort of agreement between the prosecutor and the defense and the court. So there are some differences about how that determination is made by the team, but it does need to be a team-involved determination, once again based on specific criteria, as specific as you can get them. And of course, for the defendant, you want, in general, their participation to be both knowing and voluntary. Defendants, however, don't have a right to entry into mental health court, just as they don't have a right into entry into any other problem-solving court, of which I'm aware. Defense counsel should also be involved. They should have the ability to review the agreement that their defendant is signing on to. They should understand what the team is about, what the role of the team, and they should be a participant along the way. If I don't remember to say it later, I'll say it now. They will also be a participant in the review hearings that, I mean in the staffing sessions that precede the review hearings, so that the defendant's counsel, not the defendant, the defendant's counsel being present understands what's being reported to the judge from the various participants in the team. And of course, as with any of these programs, you want to identify potential participants as quickly as possible. I think we can all understand why someone with a mental illness who is already involved in the criminal justice system needs to be engaged with resources that they may not be getting for whatever reason as quickly as we can. So early identification is important. Mark, did you have a question?
I do.
Right behind you, Mark.
I was just wondering clarification of that last point, and curious about how you balance a client who has a limited mental capacity with the notion of them making a voluntary and knowing agreement to enter into a program such as this.
Well, I'll try and answer that off the top of my head. In the first place, no one that I'm aware of has been in our, I can say this with confidence, no one who has gone through a mental health court program like this in Arizona who has not already been adjudged competent, or maybe I should say it in the reverse, who has not been adjudged, who has been adjudged incompetent. So the first place, they've met the legal standard for competence. That's not a complete answer to your question, because there still is the issue of whether this person really maybe really understands what they're getting into. But I'm not aware of problems that we've had in that regard in Arizona. And we have another question in the back of the room. I'll get that one. It's just quicker for me.
I don't know if Arizona has a drug court program, but how do you handle a dual diagnosis where they are diagnosed as drug dependent and also mentally ill? How do you determine which program, or is there kind of a hybrid where they both work together?
Well, so far in our court, we do sort of a triage, and in general, they get put in the mental health court, because the mental health court is going to address these co-occurring disorders. in that program. And I think most of the research shows today that if you don't solve the substance abuse problem, you can't solve the other problems. So I think a lot of the emphasis early on in the program, and we'll talk a little bit about the stages later, is on addressing the substance abuse problem. But then at the same time, they will be getting mental health treatment services of varying kinds. So I think in general, at least in our experience, I don't know what's going on in other courts in our state for sure, but you'd find those people mostly in the mental health courts. Nicole, did you want to comment on that at all?
Sure.
Here.
So what I've seen nationally is that there is a trend towards trying to identify the triage intake process for all problem-solving courts. So this way, when there's lots of different types of problem-solving courts, we've got veterans courts, we've got DUI courts, drug courts, mental health courts, trying to identify better ways to screen for which program is ideal, and a lot more collaboration between the different dockets. I think historically it's been much more siloed of, you know, you're here, oh, maybe you should be over there, we'll transfer you over, and then after a year, maybe that wasn't the right place. So there is a trend that way. It really just requires that the different dockets are coordinated in some way and identifying people through a triage process early in the process.
Tom, did you have a question?
Yesterday I attended the two-part session on human trafficking.
I'm sorry, those are difficult sessions to sit through.
Yes, and he asserted that many of the victims of human trafficking suffer mental illness. Do you get many referrals through that route?
Interestingly enough, we don't have any that I'm aware of that have come through as being trafficked. But at the same time, I can't tell you I could identify the characteristics of each individual that's gone through a mental health court. Oddly enough, given our location and given all you hear about the border, although we've done a lot of preparation for dealing with sex trafficked folks, especially young folks, it has not been identified as a major problem in Arizona to the extent that there's specific enough legislation, particularly criminal statutes, to allow us to deal adequately with it. Okay.
Can you just describe it's a broad range of crimes that people are arrested for that come to mental health court, or is there particular ones that stand out?
It's a pretty broad range for us. I mean, I think you would find all manner of crimes for us, from simple drug offenses or from someone who's had an accumulation of, you know, the minor public nuisance kinds of crimes, but found themselves in a felony in court all of a sudden. And you'd probably find domestic violence perpetrators up there. As we all know, people with mental illness are often victims themselves, and their family members are often victims of the folks with mental illness. So you'd see a lot of probably people with DV and other forms of violence. You're not going to find a lot of murderers and high-end violent crimes in the mental health court, I don't think. But did you have a comment, Nicole? Okay.
I think usually they exclude violent crimes. Sometimes there's statutory rules about excluding DWI, DUI. Gang-related or weapons are typical exclusions, and sex crimes are often seen as excluded. Other than that, I would say everything is included.
Yeah. So trying to move along a little bit, I mentioned the referrals, and I should strive to say, I talked about the timing of it. The important thing is that anyone ought to have the ability, anyone in the system ought to have the ability to refer a defendant to the team for consideration for participation. So if you haven't done that, if there's only one door they can go through, that's probably a mistake. You ought to think about being able to let them come in through any door, at least for consideration of the team. Now we'll move to the third standard, which is program structure. The recommendation of the standards is that the participants go through these programs in stages, and there are 4 stages. The first stage is termed an orientation stage, where they sort of begin to understand what their obligations are in the program. They get used to the number of referrals for treatment that they've got, and they get used to keeping appointments. You're acquainting them with how the court process is working. their appearances before the judge, that sort of thing, their relationship with a probation officer in terms of a post-adjudication program like ours. So that's referred to generally as an orientation phase. And then you have a second phase called the stabilization phase, where they sort of settle into the program. And they have begun meeting with their treatment providers and are beginning to show responsiveness to the parameters of the program and to the court. Then the third phase is called an integration phase, and that is that's where they become more integrated in the community, okay, where they have begun to perform more normally, shall we say. They've started maybe going back to work. They've started being reestablishing relationships with friends and family. Maybe they're doing other sorts of programs in the community. So when you hear integration, that's about integration outward into the community. It is the first step of termination, if you will, of I don't want to use that same word again, of preparing them to go back out in the community. And then the final stage is the sort of the maintenance phase, where they have gotten themselves back integrated in the community. They've cooperated in their treatment plan and their case plan. They're meeting with the providers, et cetera, and they've reached this maintenance stage where they're sort of just in that slot, if you will, moving toward progression into the community and out of the program altogether. I don't think there's anything else that I need to highlight there unless someone has a question.
I would just mention that the committee did struggle a little bit because I think the initial standard talks about graduation in that final phase.
Right.
Probation told us we don't think of it as graduation. We think these folks have ongoing needs and whatnot. And so, not to belabor this, but you'll see the wording there to say that the court may wish to acknowledge that, recognize it, whether it's a certificate or it could be a graduation. But we know it's really important to the defendants and
Right.
a lot of times to their family and kind of their support system. So.
Yeah, I just want to comment. Nicole, toward the end of her remarks, talked about the research, and I just want to emphasize as well that a lot of what's in the mental health court standards today is based on the limited research that she mentioned, but also on drug court research. There's a substantial body of drug court research. There was some doubt, at least in our Arizona committee, about the full application of the kinds of things that you pull out of the drug court standards and into the mental health court standards. Just to exemplify the example that pops up to my mind is the concepts of sanctions and incentives, okay, for participants in a program. The drug court research shows that both sanctions and incentives work pretty well, meted out properly for drug court. But the question also in mental health court, sort of alluding to what you mentioned, Mark, is are the same sorts of incentives and sanctions going to be well understood by the mentally ill person, and will they have the same effect? I don't think the research has demonstrated any of that yet, but we've built that sort of concept in that you need to have those sorts of things, but it's all still a little uncertain as to what's going to prove most viable with this particular segment of the community. Court proceedings, a single assigned judge, so that the person sees this judge consistently. They'll develop a relationship with that judge. Hopefully the judge will serve on the mental health court calendar for at least 2 years. You heard Nicole say, I'll reemphasize that the judge also needs to be one who's willing to engage in further education and understanding a whole lot more about mental illness and about the process that these folks go through and how those folks how they seek treatment and get effective treatment. I don't think there's too much of a surprise here since a majority of the room had problem-solving courts. Once again, there's a staffing before the review hearing. All the members of the team are present for that staffing, including, as I mentioned before, the defense counsel. And then essentially you go right into court where the judge gets the opportunity to interact with the participant. And the interaction is important because the participant needs to get the feeling the judge understands their circumstances and is a real person who is helping them through this problem that they have. And at that same time, the participant needs to be allowed to participate in the hearing and exchange their thoughts about the program, how things are going, perhaps about their treatment. Whatever is important to them, they need to be able to express that to the judge so that they get a responsive reaction from the judge. When it comes to treatment, it's especially important that there be a written case plan for each participant, and that's something that has sort of standard parameters, and it must, of course, be evidence-based. So kind of going back, I guess, to that earlier question about assessment instruments, it's really, just as Nicole said, you're relying on the clinical professionals to tell you about the status of this individual and what that person is dealing with and what you may have to deal with in the court setting as well. So once again, it's a team evaluation sort of approach, but at the same time, you need to have kind of a standard case plan, or at least a standard framework, let me put it that way, that each participant is put into. But then the individual elements of that plan, of course, are tailored to the needs of that person. You may have someone who is in both substance abuse treatment, mental health treatment. You may have, I dropped, give me some other ideas of what else folks might be engaged in if they occur to you.
They might be dealing with trauma.
The trauma-involved persons may need some special counseling on that. You're going to, of course, look for licensed professionals to do this, people with experience, and you also need to be very clear in the case plan what the participants' responsibilities are, so that they have an idea of what is expected of them, and they know what sorts of behaviors or performance, maybe that's a better term to use, might lead to their separation from the program. So you need to give them a grounding in that so they're not being hit cold with some sanction or some threat of being pushed out of the program. I'm going to move right along because we're running a little short on time. Standard 6 is a standard that's devoted to making adjustments in the treatment plan, and it talks also about incentives and sanctions. And once again, your policies and procedures need to lay out what the process is for making adjustments, for introducing incentives or sanctions. It can't be something that's ad hoc. It can't be something that's subjective. You need to have some objective, once again, evidence-based criteria for making adjustments to the plan or for applying incentives or sanctions. You also need to be consistent as you do this among all the mental health court participants. That's kind of a due process sort of thing. You want, because these folks seem so different in their issues, or in their issues perhaps, I think you have the tendency to want to sort of over-individualize some things like these sanctions and incentives, but that's how in a court a judge can get him or herself into difficulty if they're administering widely different incentives or sanctions for people in somewhat similar circumstances. Jail terms, something of some controversy. I think the research suggests pretty much that jail as a sanction does not seem to work for a mentally ill person. Certainly, I think our general logic, those of us who have toiled in this field for a while, would say, well, of course, if you've got a person who has trouble dealing with the world as it is, and it's perhaps under various mental health treatment regimens, if you will, maybe even substance abuse, you throw that person in jail as a sanction, all of a sudden they're not getting the same treatment. They may get some attention in jail for their mental illness, but it's not going to be the same provider. You know, even 5 days in jail may be overwhelming for a mentally ill defendant. First and foremost, of course, you don't just boot a participant out of the program out of a clear blue sky. It's like progressive discipline. You start with these adjustments to their treatment plan, their adjustments to their case plan or their treatment regimen, and then you, if necessary, you gradually tighten down on those adjustments, maybe have some sanctions before you get to the idea of pushing them out of the program. Standard 7 deals with confidentiality of records. Courts, of course, are not subject to HIPAA. but we've taken the cautious approach, and I think that's what's recommended in the national standards, and that is that you get HIPAA agreements signed with the participants, because you may be sharing information with agencies or among agencies that are subject to HIPAA requirements. So the cautious thing is to pass a HIPAA waiver document through the defense counsel, have him explain it to the participant, and have that signed. This section also deals with records retention and destruction. It's important in this area as it is in any other area of the courts. Now, Standard 8 deals with the idea of sustainability. It's important to be able to sustain these courts, to do the kinds of things you're seeing up here on the slide. The public needs to be more aware of what's going on in mental health courts and the good that the courts are doing. That's the only thing that's going to sustain us for the future. I've been around long enough, as a few people in the room have been, to know that the expenditures that we make, the effort that we make in courts on these substance abuse, problem-solving courts, does not often get repaid to us in terms of new money flowing back into the courts. We relieve the burden on the jails, in some sense, on law enforcement through our drug court programs, our mental health court programs, our veterans courts, but the money doesn't always flow back to us. And it is time that we begin to develop more public awareness of this so they understand. I don't think I'm going to cover any more of these because I want to give you at least a snapshot of the specific measures. I'm afraid I don't remember. Yes, okay. Nicole made reference to the national standards having 14 different performance measures. That was, as she indicated, somewhat controversial in Arizona because we hadn't done much data collection up to this point. And quite frankly, some of the data collection that's recommended in the standards is a little bit tricky because it relies on the court to try and collect data from providers, or relies on the court to provide incentives to the providers to provide data. But these are the measures that we've agreed on in Arizona and have been put forth as an expectation for those of us that have mental health court. Attendance at the hearings, are they present for the hearings? How frequently are they present? The attendance at their sessions. And we're also going to measure the time from arrest to referral. Once again, that gets back to the immediacy of wanting to get these folks who are criminal justice system involved in these programs. Also measuring the time from when a person is first referred to the program to when they're actually admitted to the programs. Obviously, you want to shorten that time to the extent you can as well. And then measuring total time in the program. How long does the typical defendant, participant, I should say, take to go through the program? What sort of are the parameters? The same kinds of things you do in measuring caseload. You know, who falls into which buckets, et cetera. And then, of course, the most concerning statistic perhaps is in-program reoffending, because of course that's what you're aiming to deflect, to prevent. So that's a quick brush through of the standards, and we're down to about 1 minute by now, Tina. So I should pause now and ask if there are any more questions, because some of you, yeah, go ahead. Tom.
On one of the earlier slides, there's brief reference to the Affordable Care Act and insurance.
Mm-hmm.
What really wasn't mentioned. So what happens if a person doesn't have insurance or if it doesn't cover, the treatment because it's pretty expensive? Does the state pick that up?
I can try to take that.
Okay, go.
The majority of the courts in Arizona require you to have access or Title 19 so that they do pay for the treatment. There were a handful of courts that allowed others to come in with private providers who had their own insurance companies to pay for it. The critical piece was that they really wanted to have a clinician or a provider to be able to give regular status reports. If that can happen, it seemed as though the mental health courts were willing to take it from whatever source, as long as they were willing to provide that information. So that was the biggest caveat. But a lot of these people were indigent and qualified.
Access is the Medicare name for the Medicare provision in
and so
Arizona.
I
provided most of it. That was the majority of the clients.
I just wanted to thank you folks. You've been terrific, and I think our panel, these folks are just so informative. So thanks very much.
Thank you. Thank you.